Our second case scheduled for oral argument this morning is State versus Luis Antonio Perez Franco. You may approach counsel.
Thank you, Your Honor. May it please the court. Good morning to everybody.
Again, counsel, we will allocate 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
I would like 6 minutes, Your Honor.
So noted, Madam Clerk. You may continue, counsel.
Thank you. My name is Darren Shippey. I represent the state of Florida in this appeal. And since we're here with a legal writing class, I want to pay some compliments to my opposing counsel regarding the drafting of his brief. It was very well written, very entertaining, and it was Ms. DeSantis, I believe it was. I would encourage her to provide a copy to her classes to read, not because that I think he should prevail today on behalf of his client, but it is a very well written brief, and I read a lot of briefs, so I'll compliment that when I see one. Having said that, I need to confess my own error in the drafting of my brief. I'll bring the court's attention to, I advised opposing counsel this morning. I wrote in my brief that the two defendants, and I'm going to refer to them as the dad and the son. The son's case is on appeal. The dad's case has been resolved. I wrote that both of them had been convicted of the same offense, which was attempted aggravated battery in possession of a firearm that was discharged. I was wrong. I don't know what happened to make me wrong, but Dad, in fact, was found guilty of even a lesser offense of aggravated assault with a deadly weapon. It will not alter the arguments that I'll make, but as it relates to the principal argument that we'll discuss in a few moments, we'll be substituting the dad's charge of aggravated assault with a deadly weapon as opposed to attempted aggravated battery with a weapon that was a firearm that was discharged and possessed and discharged. Having listened to the case just before us and the recitation of various cases that came out of the district courts of appeals and whether they control or not, that is not what this case is about. This is a case where the trial judge, after the verdict, several days after the verdict, issued a notice that he called a notice of intent to consider alteration of his interlocutory rulings.
Does the fact that it was 11 days after the verdict make a difference? You made some mention about the timing and when the defendant would have had to file a motion.
So I did the math on that, and my math said that it ended on a Sunday, so it would have carried over to Monday. So I won't.
But even so, 10 days, 11 days, taking that time period out, did the trial court have the authority to sua sponte revisit his ruling on this kind of motion, a motion for judgment of acquittal, without obviously sua sponte, so without the defendant making the motion or renewing the motion?
I believe so, only because I think the court has the discretion to revisit its earlier rulings. Had it done so perhaps without the benefit of conducting a hearing, there might be a different argument that would be raised. But I think generally speaking, a court has the ability, before it imposes judgment and sentence, to reconsider what it did earlier in the hearing.
Does the court have the authority to consider new arguments that it comes up with on its own that weren't made in the original motion for judgment of acquittal?
Well, that's part of the concern and objection that I have to what the judge did. First of all, he put in his notice that he was readdressing the issue of intent. That never got discussed whatsoever at the post-trial hearing. And essentially it went off on a tangent that really almost had nothing to do with the motion for judgment of acquittal, which is bothersome because the state and defense were both on notice that we're going to readdress things as of the initial motion for judgment of acquittal. The renewed motion for judgment of acquittal essentially was perfunctory and served no purpose other than adopting what was said before. So it's concerning that what was not discussed at the motion for judgment of acquittal is a part of what becomes in the record, what happened at the post-trial hearing. The only argument that the defense made regarding the son, case on appeal for y'all, is that there was no evidence that the son discharged the firearm. That's it. So when you read that argument, you listen to the state's counter argument, what I have to say today, the judge went off in an entirely different direction, and I'll speculate for a moment why that may have been.
But that would be, so on the question, the JOA motion made after the close of the state's case focused, it was limited to, they didn't prove attempted first-degree murder, and they didn't prove that he discharged the firearm. There was no evidence of that. That was their JOA motion.
I agree.
If the judge had agreed at that time that while they didn't prove the discharge, what would the judge's option have been? Isn't that a request for an acquittal down? Like, wouldn't that wouldn't have, if the judge agreed, wouldn't the judge drop the charge down, or like when it goes to the, like tell the jury at that point, now you're only going to consider this issue?
Yeah, well, that's what the rules require.
Right.
That if the evidence does not support the highest charge that the defendant's been charged with, then you drop it down to the next one, but that's not.
In other words, it could still go to the jury on the lesser included.
Oh, absolutely, and that's part of the complaint that I have in this respect, that the.
So, yeah, why, so at the end, so this is, the judge is reconsidering his ruling at the end of the state's case, and then concludes, okay, now roughly, I'm roughing it here on reading the order, roughly concludes, yeah, I don't think there was evidence of discharge. I'm being loose with it, but go with me on this for a second. Wouldn't it have been the same thing, his options would have been the same at the end? Wouldn't the option then be, okay, I'm going to strike the, that part of the verdict, or I'm only going to enter judgment on the part of the so basically the ag-bat, or attempted ag-bat, period, without the enhancement for the discharge? Wouldn't that have been his option? It's basically an acquittal down after the fact, on that same conclusion.
Yes, that's the analysis that should have occurred. The rules contemplate, the case law interpreting the rules contemplate that that's why prosecutors in closing arguments get up and argue, this is the highest, this is what he's charged with. However, there are lesser included offenses. The judge has that same obligation, but what he did in this case is he zipped forward to, you know what, I'm just gonna JOA the whole thing, and didn't go through an analysis that I believe he should have gone through to determine, well, what was the charge at the motion for judgment of acquittal stage, the initial motion for judgment of acquittal as he calls it, and what was the evidence and how does that match up? But he went off on a big time left turn, got lost in the woods, starts looking at the information, starts basically getting wrong what's in the information, gets really hung up on a case that he presided over, where this court, in an attempted second-degree murder case, made a finding on appeal that there was insufficient evidence to prove depraved mind, has nothing to do with this case, and then just continued on from there and said, having considered it all, he's guilty of nothing.
So I read Reno. Reno didn't say very much.
I'm sorry?
I read Reno. Reno didn't say very much.
And I've noted in
What
there.
the
that's
judge says about Reno, I don't get from reading the Reno opinion. Maybe that's because he was the judge on Reno below and reads too much into the Reno opinion.
That's a very fair statement. So Reno is literally one column, and when you read his order that refers to Reno, he goes into all sorts of stuff that's not in the record in this case, which once again would make it impossible for the state to respond to it. And that's part of what I point out in our initial brief, that first of all, it's the holding in Reno, you can't transfer what happened in this case. It's not an attempted second-degree murder, is the issue of depraved mind, what we're discussing. That's not what was discussed below, never even came up till he brought it up sua sponte and kind of caught everybody off guard.
The discharge with respect to ag-bat or attempted ag-bat, that's for 1020 life, right?
That is the significance of it,
That's the
yes.
enhancement, which means that, you could cut that part out and you I mean, it's basically, it's a necessarily, it's category 1 kind of lesser included, you know, like,
I understand what you're saying.
it's a little weird because of the nature of it, but that enhancement has to be proven beyond a reasonable doubt to the jury to increase the sentence. In Florida, unlike federal law, in Florida, that is considered then an element of the offense because of that. And you could cut that out and you would have attempted ag-bat with discharge or attempted ag-bat blank. So, which means you have a freestanding offense without that discharge.
I agree, you're correct.
Which
You are
then,
correct.
so then with the whole notice thing, this issue about, well, it wasn't charging the information, or, you know, that wasn't what was originally, charged. The fact that the defense counsel, agreed with the lesser included, all 6 of them,
Yes,
agreed to the verdict form
yes,
with the check boxes,
yes.
doesn't that eliminate any argument about notice at that, you know, if that were part of the argument? It's like, well, because that's part of the judge's order, is, well, but that wasn't what was charged, the whole discharge thing was possession.
Well,
Why would that matter, I guess, at this point, based on what happened at trial?
Well, I hope you're asking that it benefits the state and not the defense, because it went to the jury on that, and the case law does say that when it goes to the jury, not that there was a defect in the information, I'm not gonna suggest that, but it's been cured to the extent that the jury had the opportunity to receive an instruction on it. They had a verdict form, we're not at issue with whether they made a finding or not, they did. They found not only did he possess the firearm, but he also discharged the firearm.
But do you agree with the appellee that he was not found guilty as a principal by the jury?
No, I don't agree with that. I believe, based upon the jury's verdict, that the jury found him guilty based on his own conduct. So I would respectfully not agree that they've got it right, that this was a principal situation. There's an argument for a principal. There's an argument for a principal as it relates to a lesser included offense, which would be, in this instance, the ag assault. But in this instance, the evidence, even though the defense does not like it, it's there. It supports the jury's verdict. There's more than one
So
witness.
what is the evidence that the appellant discharged his firearm?
You and I are thinking the same way. I'm getting ready to tell you that.
Okay.
Multiple witnesses, 3 witnesses testified to hearing up to 4 shots. That's number 1.
But no witness testified that they saw the appellant fire his firearm?
No,
Okay.
didn't happen. He was behind the trees and hidden from view at that point in time. You don't see him on the video shoot it. You do see his dad on the video shoot the firearm.
Yeah, at least once.
At least once, yes. And glad you brought that up, because what happens is one of the victims, Robert Carter, who's the second victim, the one farthest away from where the shooting's taking place, he ducks after 1 shot. 8 seconds later, he ducks again, and that's after Dad is just about left out of the picture. And then you add to that when you look at the video, and the exhibit you want to look at is Exhibit 7, Camera 11, over on the left-hand side of it, there's these row of trees, bushes, whatever they are, going on the dirt road. There is a shell casing found that was not found originally. They did not find a shell casing on the paved area where the gas pumps were and where the father would have been when he discharged his firearm. Back going in down this dirt road, which is the way they would have gone back to the house they were coming from, there's a shell casing found. But it gets worse for the defendant. Not only is a shell casing found, but when he's taken into custody 8 days later, he's got on him a firearm. Well, continues to get,
Glock 23, correct?
that is correct. But it gets worse for him because,
But that's 40, that's 40 Smith & Wesson, correct?
yes,
Okay.
so gets worse for him
And
because
so
they
that
do
was, that was the gun he had,
that's the gun
and
he's
the cartridge matched that caliber,
That is correct.
okay?
So,
And so tell me about the testimony of the firearms examiner. Was she able to testify that that cartridge was an exact match, was from that gun, or was she able to just testify that that cartridge was consistent with that gun?
Well, I think all of them would testify that it's consistent with having come with it.
Okay.
I'd have to actually double check my notes, I'd be happy to do
So what
that.
kind of firearm did the father have? Did he
We
have
don't
the
know.
same kind of firearm, but
We-
a different one? Cause you know, if they were shooting different firearms, finding a cartridge, you know, if he was shooting a 9 and then the appellant was shooting a 40 Smith, okay, that might prove something, but if they were all shooting the same caliber and gun, especially the Glock, cause they're so consistent in their manufacturing tool marks, I don't know what that shows.
The firearm used by the dad was never recovered. I recall that the testimony is
Do
one
we
with-
know were there any other cartridges and
No.
what caliber they were?
No. So
With
what
all
you
that
have,
said though, counsel, was the state seeking a conviction at trial based on the theory of principle or actual discharge of a firearm?
I'm sorry, would you say that again?
Was the state seeking a conviction at trial based on the theory of principle or actual discharge of a firearm?
I think that they were seeking one based on both, and the state would not be precluded from arguing in the alternative. In this instance, they argued, and the jury was instructed, the jury specifically found that the defendant, the son, on issue and appeal here, possessed a firearm and discharged a firearm, and I would respectfully suggest it's gonna be based upon the testimony that you and I just talked about, which was the recovery of the shell casing back behind the area you can't see, that then matches or is consistent with the firearm that's recovered from the defendant 8 days later, that his girlfriend, wife at the time of the trial, I think, testified he always had it with him. So the guns were different. All right, so that's number one. I think the jury found him guilty based upon the verdict, based on his own conduct. I think there's an alternative argument that the state was putting forth, which was that he can be liable or guilty as a principal to what the dad does. And you can look on the video and see that the whole thing, they're both right there. They're charged in the same information.
But not for purpose of enhancement.
Not for, oh, no. But for purpose of, as you described earlier, the charge.
The act that itself.
Absolutely. And you would have bumped it up to the attempted first degree murder, which then the jury didn't find. Drop it down, attempted second degree murder, nope. Attempted aggravated battery, yes, that's on the son, and then for some reason on the dad, aggravated assault, the deadly weapon presumably being the gun he discharged. So I think it's both principle but the jury's verdict was based upon his own conduct, because it has to be in order to get the enhancements. And that's a material distinguishing factor between the potential sentences, I should say, that the son faces versus what the dad faced. It went from, even though the attempted aggravated battery is in fact a third-degree felony, the same as aggravated assault with a deadly weapon, with the finding of possession and the finding of discharge, the sentence changes dramatically.
Did the attempted aggravated battery conviction require discharge of a firearm?
The attempted aggravated battery,
Yes.
would it have to? I cite a case in my brief that came out of the 3rd District, and I think it's Washington versus State, that talks about what was sufficient evidence, and in that case they talked about a discharge of a firearm. I was trying to find something that matched up a little bit close to what we have. So attempted aggravated battery is I attempt to commit a battery, and then I'm unsuccessful in doing it.
Battery requires the touching.
Well, it does, but if we're attempting, and in this instance, that there is, I lost my train of thought. There's the attempt, plus in this instance, there's a deadly weapon. So possessing the deadly weapon would be sufficient for to bump it to the aggravated battery part. That's what makes it. If you got aggravated battery, it's because I possess a deadly weapon or I intend to commit.
Well, that would make it aggravated if it was a battery. And an attempted aggravated battery, you have to have an attempt to touch, but you don't actually touch. So I would think that if you point a firearm at someone and you don't discharge the firearm, That's ag assault.
Yeah, it would be, for certain, but if I also take a battery and take a gun and I swing it at you, and I miss, because I'm not very good at swinging the gun, that's attempted aggravated battery, because
Or-
I'm attempting to commit a battery, and I've,
But my point is that the attempted aggravated battery requires a finding that the gun was discharged.
in the unique aspects of this case, yes.
Yeah, okay.
Yes, in this
But-
case, yes.
But the principal theory gets you almost all the way. The principle, you just have to stop short of the discharge of a firearm for the enhancement, right? So, all of this could have happened, his partner could have been doing all of it, and he happened to just, be aiding and abetting for the most part.
Yes,
The whole
absolutely.
thing,
Well,
And then you get your attempted ag back, you just potentially have a problem with the discharge.
well, if we look at the, I'm sorry, didn't you?
Yeah,
Yes.
So, I mean, you can, obviously, the primary person, can discharge a firearm,
Yes,
and you can show that that person discharged a firearm. And on the principal theory, so the aid and abettor can just help him and not discharge himself, and still be guilty of the attempted ag back. Is that?
I agree, 100%. And if we use
So
the.
we're really just talking about the enhancement. At the end of the day, this is about the 10-20 life enhancement.
You're
And
right.
was there enough evidence to show that Mr. Franco discharged a firearm himself for purposes of the enhancement? Is that about right?
I agree. Because in this instance, even though, so let's say the jury finds Dad, who's on the video, pointing the gun at Carnes and Carter, shoots the gun, that would match what you're saying is an attempted aggravated battery, would match what you're saying is an attempted aggravated battery. Son being there the whole way, he's driven him there, they've got out together, they've crept up there, they both pointed guns at Carnes, they leave together, so it's clearly the two of them acting in unison. So there's no way that the defendant, son, is not a principal to what Dad did. But for whatever reason, the jury in this case found Dad guilty of aggravated assault with a deadly weapon as opposed to attempted aggravated battery. So I believe factually the son is guilty as a principal to attempted aggravated battery, and then we can argue all we want about the possession and discharge. But the jury found him guilty of a lesser, so I think legally I can only argue that he's a principal to what the dad was convicted of as opposed to something he wasn't convicted of, if that makes sense. If I go to trial and you and I are both charged with first-degree murder, and you're convicted of second-degree murder, if I'm going to be convicted as a principal of that, I don't think I'm convicted as a principal of first-degree murder. That's the best way I can explain that. So I think y'all have hit the nail on the head, but I want to make sure that you understand when the judge went back to the motion for judgment.
Counsel,
Yes.
your time has expired, including your rebuttal time.
Okay, then I will sit down and mind my own business. All right,
Thank you,
thank you.
counsel.
May it please the court, Robert Berry on behalf of Mr. Franco. Let me start with one thing before we get into the law part of this. Let me discuss one aspect of the facts. The video, the beauty of video and audio in this case is that you can combine the two. I have done it, and it's easy to do. The court can do it on its own. And as you were talking about in the last case, you can view the videos and the audios yourself and tell what happened. But the problem factually with the state's continued contention that the dad and son walk up to these guys face to face, and they both have guns out. They're not charged with that for some reason. Son walks away, all the way back to the car that was parked out on the dirt road. Dad walks about halfway, turns around, one of the gentlemen ducks, then the dad resumes walking out. You can see, if you match it up with the video, you can see there's a guy in a pickup truck right next to the dad, who doesn't seem to react or any alarm. There's also the lady who made the 911 call, Ms. Larkin, who's standing with the door open at the convenience store narrating what's happening. She's talking about two guys with guns approaching these two white guys at a gas pump. They're walking away, doors open, you can see the point at which, and combine the sound with it, the point at which Dad turns around halfway in the parking lot and points the gun, and you don't hear any gunshots. You then get back to where Dad walks to where the car is, and you hear on the audio of the 911 call, bang, bang. 2 quick shots. Lady says, oh my God, he's shooting. And she closes the door, probably locks it for her own safety. And she testified at trial that whatever shots you heard occurred during the course of the 911 call, and you can hear them loud and clear. When the gun is supposedly farther away from her than the time that the state continues to allege, and I argued it to the jury, that the dad turned around and fired a shot at that point in time before he goes all the way back to the car.
So based
He
on,
makes a,
based on everything you just talked about.
Right.
Do you agree that you have, at a minimum, attempted ag-bat, at least with respect to the dad? And that's just from the video and the audio, without, we haven't talked about the testimony from the victims that were there, but just on what you've just talked about.
if we're assuming that Dad fired the 2 shots,
Right.
then yeah, you got attempted ag battery, but the jury found him, as we
But that doesn't
talked
matter for
about.
purposes of your client's conviction, because you can be convicted of being a principal to a crime even if the co-defendant is not convicted of that. Is that not right?
I don't agree to that on these facts. You may have a case in mind. I couldn't find a case where the co-defendants were tried together. That's what makes this interesting.
But no one
I can
argued
imagine
legal-
2 separate cases and somebody griping on appeal that, hey, my co-defendant in a different proceeding got found.
But no one argued that these were legally inconsistent verdicts.
Nobody argued much anything in this case, Judge, frankly. I mean, the question is whether, I'm obviously, and actually, let me go back one thing. In the spirit of confessing errors, I thought the judge had at least noticed my point that the charging document didn't contain, or did not charge my client with discharging a weapon, because in neither count is he charged with that. The question is whether this is coming back post-sentencing for review on certain aspects of this, or worst case scenario, or 3850, where I'm back in front of somebody talking about all the waivers that are going on in this case, because attorney this is frankly a pox on everybody's houses. But I try to credit the judge in trying to get it right. He does, I think, contrary to what y'all were discussing, the state was discussing earlier, does his best to analyze the lessers and says there's no evidence that my client, he wasn't seen discharging a weapon. They have their circumstantial evidence point, and
But that's just on the discharge. Let's assume that the judge got it wrong on the or was right on the discharge part. That would just strike out the enhancement. What about the rest of the case? Like, why does your client get to walk? Despite the evidence.
because
that
of the
was
way the
presented to
state
jury.
charged it.
But
And
why
again,
does it matter how the state charged it? Because trial counsel for Mr. Franco agreed to the lesser, all 6 lessers, agreed to the verdict form with the interrogatories, asking the jury to check. If you find, first the question is,
Preaching to
did
the
he
choir.
commit attempted aggravated battery? If yes, now tell us one of these other things.
You're preaching to the choir, Judge. I mean, the trial attorney said he looked at the verdict form the night before, and based on what he remembers, it looked fine to him. And obviously, in any post-conviction litigation, that problem will be discussed at length.
But
My
is
point
it
is-
the role of the trial judge now, and this court now, to fix these things? Or is it just to look at what the errors are on the face of the record? And, if there's a 3850 motion that comes later, that's not should that be our concern now?
No, it shouldn't. This is, I'm down, especially with my concession early on that the judge didn't even seem to understand the problem with the charging document as it related to what went on as the prosecution continued. And
Which is what happens when judges freelance instead of just ruling on motions that are presented to them, right?
well, I think he was justifiably troubled by the fact that the person who was charged with discharging the firearm gets an ag assault, and the person who's not charged with the firearm, discharging the firearm, gets convicted of a more serious offense and discharging the firearm.
Yes,
He is
then,
no-
counsel, but
I'm sorry.
how was Appley prejudiced by the state's failure to charge him with having discharged a firearm?
How's he prejudiced? Well, I want to make sure I
Right,
understand your question.
again,
How
how's
is he
Appley
prejudiced by the failure
prejudiced
to
by the
charge him?
state's failure to charge him with having discharged a firearm?
He's advantaged by that failure to charge it in the first place. He's disadvantaged by everything that happens afterwards. His attorney's silence in opening, his attorney's silence during closing, his attorney's silence on how the jury is instructed, and
Well, he
you
wasn't
can't
silent. He
waive.
wasn't
if
silent on that question. From opening statement through the JOA motion, it's talking about the discharge of the firearm, and that the state did not present evidence of the discharge, which presumes that the whole trial was, at least from the state's perspective, was tried on the question of discharge. Defense counsel knew about it, and defense counsel then waited, saw the evidence, and then made the argument in JOA. That's a
They
different.
really didn't
That's
do
different
that,
than,
though.
huh?
They really didn't do that, though, did they?
I'm sorry.
They really didn't do that, though. Not in JOA. It was a pro forma JOA
Well, I
argument.
don't see-
It
I mean,
wasn't
there was a
saying,
whole-
Judge, my
It was a
guy
whole
isn't even
page in the
charged.
transcript. I mean, it was a whole page. I mean, that's more than
A whole
many.
page.
But he did make I mean, he did say, hey, they didn't present evidence of attempted first-degree murder, and oh, by the way, and they didn't present evidence of discharge of firearm by Mr. Franklin. I mean,
They found that he discharged the weapon.
but the jury did, right.
Right.
But arguing that while your client was disadvantaged because it wasn't a charging document, I don't see how
No,
that plays
no.
out.
The problem is that the verdict does not reflect the charging document. He is under no theory, under no lesser, would he be a person who discharged the weapon. Under no conceivable lesser could he, based on how he's charged, what happened in the aftermath of what he was charged with. And here's the problem.
But
Here's the
still,
problems
your
I see it
counsel-
when you.
Did the appellee ever object to the state's arguments or to the verdict form regarding the discharge of the firearm on the ground that it was not charged, he was not charged with that?
No, he didn't.
Why didn't the appellant then waive his arguments, or why haven't he waived his arguments on appeal
Well,
regarding
Here's
this
how
issue?
Excellent question. Here's how I understand the law. State makes a charge, and based on this court's decision, which was given the imprimatur of the Florida Supreme Court, the state can move to amend the charge after the state's arrested their case, and that's okay. That didn't happen here. And if we're gonna say waived, I don't see anywhere on the record where it reflects that my client was asked by the court, do you understand that by allowing the state to argue this uncharged discharge issue, that you're exposing yourself to a significantly much greater sentence? Waiver ought to require at least some knowledge on my client's part before he exposes himself to a far greater sentence than the charging document puts him on notice of. But I mean, you know, it's not curious. He doesn't understand that point. He might if somebody had talked to him about it. But I think the idea of waiver of something that serious requires something more than just silence and nonfeasance by a criminal defense lawyer. I think that, as I told you earlier, this is a tipsy coachman case. The judge got it right because there isn't, once the state was asked to argue principles, first of all, there's an inconsistency with the verdict, That may be a 3850 somewhere in the future. But all of their lessers that they want to argue were based on, well, maybe my guy tried to pistol whip that person. He wasn't charged with that. And the state said, well, you couldn't possibly charge both of those offenses because there would be double jeopardy problems, and that's ridiculous. It's not a double jeopardy problem. There's a statute that discusses the fact that, first of all, they're discrete incidents, clearly. I walk up to you and put a gun at you, and I've committed a crime at that point. But the state didn't charge
So
that crime.
double jeopardy doesn't attach to charging, that's just a concept with conviction and sentencing, correct?
Start your sentence again. I've missed the first part of it.
Double jeopardy does not apply to charges, it applies to convictions and sentences. Correct? This
the
is
state.
a friendly question.
No, I agree. No, I agree. No, I'm always. Blood pressure is too high. The state was arguing that it would have created some sort of double jeopardy problem to charge him with walking up to these guys and pointing a gun at them when that was its own crime. But it didn't charge that. But then when things start falling apart for their conviction as the ag battery with a gun, well, Judge, it could be some lesser that involves this incident at the gas pumps, which wasn't charged. He was charged with, it really is a pox on all their houses, charged with attempted first-degree murder.
But in the JOA, in the trial court's JOA, didn't the trial court err by failing to consider the lesser offense of aggravated assault?
Did the trial court err by doing that?
Yes, failing to consider the lesser included of aggravated assault.
By failing to include aggravated assault?
Consider it.
I thought they
It
did.
was a JOA, so obviously JO equates from everything.
And you're saying that it looks like the jury was instructed, and on the verdict form there's an aggravated assault option. Maybe I'm misunderstanding your question.
With it, in regards to the JOA, shouldn't the trial court should have considered that offense as well?
Based on the incident at the pumps?
Based on all the surrounding circumstances of the case. I thought about this a lot. I think at the point that both gentlemen are back at the car, and that's when the gunshots go off, the two gunshots go off. I thought about it in terms of the How
father.
many shots were fired? Was there record evidence that there were 4 shots fired as opposed to 2 that was heard in the video?
Do people testify to there possibly being 4 shots?
Yes.
Yes, but the beauty of video, to reference us back to the earlier arguments today, allows you to look at the video combined with the 911 call, and there's 2 shots. You have a definitive answer. You don't have to wonder about this one, or the fuzziness of memories, or what ricochets sound like.
But
or
the
echoes.
only audio we
2
have
shots.
is of the 911 call.
Right.
We don't have audio of all the other video.
Agreed. But Miss Larkin, the attendant or the person who ran the convenience store, testified that the shots fired were during the course of her phone call. And you can see the part where Dad walks away about halfway to the car, turns around and does this, and one of the guys ducks. Their argument is he fired a shot at that point. He didn't. Because you can put the video and the audio, you can sync them up. Because it's pretty easy. When that lady who's standing at the door opened at the convenience store slammed, oh my God, they're shooting. And she slams the door. And you can hear the 2 shots. It's easy to synchronize. Some of it's hard sometimes. Those you can actually do. And she is also out there with the door open, standing exactly the same place she is the whole time. when supposedly dad shoots from the parking lot. But the
How many
evidence.
shell casings were found by law enforcement?
2, 1.
And were the testimonies of where that shell casing came from?
A gun that was found in the possession of my client a week later. Yeah, absolutely.
Going back to Judge Lewis's question from before, and this goes actually how I opened my questioning. What is the legal argument that your client gets to walk on this? In the face of the evidence, in the face of the jury verdict, looking at the lesser included, an ag assault is on there, on the verdict form. Assault is on there, on the verdict form. So at a minimum, just at the very bare minimum, is your argument there's not enough evidence for ag assault for your client?
Here's what you have, here's how I look at it, and you like it or you won't like the argument. The charge is, and I have some history about that. The argument is that the attempted murder, first degree premeditated murder, occurred when someone fired gunshots into the air, at those people, into the ground. Nobody knows, but that's what generated
But that's not
the
even what-
prosecution. I'm getting your answer. I'm going to get to you. I'm trying. So that's the basis of the prosecution. If you want to talk about waiver, the state waived their right to prosecute the "I walked right up to your face and put a gun in it," as they did. And if they had charged that, they could have proved it easily. But they didn't charge that incident, although they want to use it as a backup to this ever-expanding theories of prosecution that don't have anything to do with how this was charged. So the way he gets to being cleared, first of all,
Do you deny that there is evidence to support, in the record, enough evidence to support at least assault?
if they had charged the
No, not asking about charging. Is there enough evidence to support assault against your client?
when the dad fired the 2 shots, there's not any evidence
No,
at
when,
that point.
when your client pointed a gun in the face of the victim, is there not enough evidence to convict him of at least assault?
If you are going to assume that that's what was charged, or is a naturally flowing thing from from what was charged in the charging document, then yes, you
What
could
about
do
ag,
that.
what about ag assault? I mean, we can roll up.
I
you know,
already
from
conceded the
bottom
point. I mean,
up.
I
Yeah.
conceded your point
So,
earlier,
let
Judge,
me-
that if
so
he committed an
So
ag
an
assault.
assault with a gun is always ag assault.
So before we
At that point in time, but the problem is the timing of it.
Before we get to the end, though, what I'd love to, and you know, while we're handing out compliments, you know, Mr. Shippey did a great job with the conclusion, at least laying out sort of a menu of options for remedy. If we do get the chance, I'd like to ask Mr. Shippey about that too. But
I don't object.
this is a mess a little bit, and let's say we don't fully agree with Judge C, and we need to fix this in some way. And let's say we agree, okay, there was enough evidence to support discharge, but there is enough evidence for ag battery. What's the remedy?
I'm sorry,
like,
ag
what-
battery?
Yeah,
Words
ag-
are critical.
Aggravated battery, or whatever it is, aggravated battery, aggravated assault, pick one. What would we direct the trial judge to do? Enter judgment just on whatever lesser included we think there's enough evidence to support?
That would be your task. My position is the judge got the end result right for reasons that he never contemplated. Bless his heart, I think this is, from my perspective, a tipsy coachman case. And am I 45 seconds over now?
You have concluded, counsel.
Thank you, Your Honors. Appreciate your
Hold on
time.
a second.
Is it possible just to bring Mr. Shippey back just to ask about the remedy?
I really don't object.
Thank
Not that
you.
I'm eavesdropping.
Oh, thank you. Well, your time is expired. Mr. Shipley,
Robert's question about what the record was.
Well, come on, man.
we'll give you a minute.
Okay, thanks. goes to, I went back and reviewed my notes in question. My notes reflect that the FDLE witness said the cartridge case was fired from the submitted pistol. That's what my notes reflect. I haven't gone back and verified the wording, but I would have written typically consistent with. So she says it was fired from according to my notes. That's number one. Number two, the record in this case reflects enough evidence to convict the defendant as charged, as the jury found him guilty. If for some reason you disagree, the drop down is not to attempted aggravated battery without possession or discharge. It drops down to aggravated assault, either based upon his own conduct, based upon either, which is a part and parcel of the same criminal episode. This is probably less than 1 minute we're talking about, where he's pointing the firearm in the face of Carnes and Carter. Alternatively, as a principal to the aggravated assault for that the Thad was convicted of. And that's the way we would view it, that.
But not ag that.
Not the attempted aggravated battery. I don't think you can
attempted
bump it up. So, thank you very much. Have a great day and a safe trip back.
And thank you, councilors, for your respectful oral arguments this morning. This concludes our oral arguments for this morning. We stand adjourned.
All rise.